Can the Philippine government actually hand over one of its own citizens to the International Criminal Court? Well, welcome to this explainer. We're diving straight into what is literally an unprecedented legal clash currently unfolding in the Philippines. It's a massive, high-stakes collision between domestic law and the ICC. We are going to navigate these incredibly complex legal waters to see what happens when national sovereignty goes head-to-head with global accountability.
To make sense of all this, we'll quickly map out the terrain. The core tug-of-war, the statutory bridge, the constitutional shield, how the dualism filter works, and finally, the ultimate Supreme Court showdown. Let's get right into it.
With the historic March 2025 arrest of former President Rodrigo Duterte via Interpol, and then that dramatic May 2026 attempted arrest of Senator Ronald De La Rosa right inside the Senate, this urgent question isn't just theoretical anymore. It sets the stage for a monumental constitutional battle. Can the government just hand over a citizen to an international tribunal? Why does this matter so much? Because it tests the absolute limits of a nation's sovereignty against the demands of international justice. And honestly, the answer depends entirely on which legal framework you prioritize.
Section 1. The legal tug-of-war, international obligations versus domestic supremacy. Let's start with the central conflict at the very heart of this issue. Picture a giant balance scale. Weighing down one side, we have international justice. This includes permanent treaty obligations to the International Criminal Court and Interpol. The government, specifically represented by the Office of the Solicitor General, argues that the Philippines is part of a global community and has a real responsibility to support credible international mechanisms. But on the other side, acting as this massive counterweight, is the Philippine Constitution, the absolute supreme law of the land. This scale is constantly tipping back and forth, representing the intense legal tension between global treaties and national sovereignty. Section 2. RA 9851, Statutory Bridge, which is the mechanism for surrender.
So how exactly does the government justify enforcing a foreign warrant locally? Well, there's a specific mechanism for that. Enter Republic Act No. 9851. Enacted in 2009, this is the domestic law penalizing crimes against international humanitarian law, like genocide or crimes against humanity. And here's a crazy fact. It was passed 2 full years before the Philippines even ratified the Rome Statute. Today, it serves as the statutory bridge for international cooperation.
If you look closely at Section 17 of this law, it explicitly states that authorities can dispense with local investigations and basically surrender or extradite accused persons to an international court. The Office of the Solicitor General argues this specific clause gives the executive branch the authority and the discretion to just skip local trials entirely. They essentially view this as a legal gateway. It's like a bridge with the word surrender stamped right over it, guiding a citizen straight from the Philippines over to the ICC in The Hague.
Section 3. Due process, constitutional shield. Specifically, Article 3, Section 1.
But wait, it's not quite that simple. Standing right in front of that bridge is an impenetrable defense mechanism, the Philippine Bill of Rights. Legal experts, like Alexis F. Medina, point out that Article 3, Section 1, acts as a massive shield. It guarantees that no person shall be deprived of liberty without due process of law. Critics argue that bypassing local courts to secretly or directly hand over a citizen flagrantly violates this absolute fundamental protection.
You see, under the Constitution, taking away someone's liberty requires strict, specific steps. We're talking prior notice, an actual opportunity to be heard, and crucially, a warrant issued personally by a judge based on probable cause. Bypassing local courts to execute a foreign warrant just doesn't fit those strict protections. Why? Because the ICC is not a lower court established by Philippine law. Their judges aren't locally appointed, and their decisions aren't reviewed by a Philippine regional trial court.
And then there's the Equal Protection Clause to consider. Think about it. If someone is arrested for local prosecution under this exact same law, RA 9851, the Constitution demands a domestic judge's warrant. Legal scholars point out that denying that exact same judicial protection to someone just because they are facing foreign surrender is a blatant equal protection violation. The argument here is that if you were being deprived of your liberty on Philippine soil, the domestic rules of due process absolutely must apply. Section 4. The dualism filter. How treaties become local law. This brings us to a huge systemic hurdle.
How does international law actually take effect inside the country? Well, the Philippines is what's known as a dualist state. Under this legal doctrine, international treaties do not apply wholesale or automatically. They have to be transformed by the national legislature into domestic law.
It's kind of like a giant filter. An international treaty, like the Rome Statute, doesn't just bypass the system. It has to pass through the Philippine Congress filter
to become an enforceable local law book like RA 9851. Because local courts are fully open and completely capable of trying these exact same crimes, this means the Constitution ultimately acts as the final filter for all international treaties. Treaties simply can't override the local Bill of Rights.
Section 5. Supreme Court Showdown, the ultimate arbiter.
So, what happens when that statutory bridge we talked about collides directly with the constitutional shield? We're left with two fiercely debated, completely opposing views setting the stage for a showdown. On one side, the executive and the OSG argue that RA 9851 allows surrender without a local trial, that Interpol red notices are enough for an arrest, and that the executive has broad discretion here. But on the other side, the constitutional view argues that due process mandates a local court warrant, the ICC has zero local judicial authority, and the Bill of Rights is supreme over any treaty.
Now, the government often cites a big 2021 Supreme Court case, Pangilinan versus Cayetano. In it, the court ruled that even though the Philippines withdrew from the Rome Statute in 2019, that didn't discharge its prior obligations to the ICC. But, and this is a massive but, constitutional experts quickly point out a major caveat. While the court affirmed the obligation exists, it never actually resolved if that obligation extinguishes the strict domestic constitutional requirements for an arrest. It didn't say you could just skip the rules.
So a huge question mark now hangs over the facade of the Supreme Court of the Philippines. With petitions and legal challenges piling up, the High Court is forced to be the ultimate arbiter. They are the ones who must decide the fate of citizens detained for the ICC.
As this legal tug-of-war reaches its absolute climax, the outcome is going to set a monumental precedent. So we leave you to ponder this definitive question. In the face of grave allegations, which must reign supreme? The machinery of international justice or the impenetrable shield of the domestic Bill of Rights? Thanks for joining us on this explainer. Keep learning and stay curious.